proving drug possession beyond a reasonable doubt is just like proving any other charge beyond a reasonable doubt. The state's going to rely on three main types of evidence. Those are direct evidence, which is physical evidence, things like fingerprints or actual pieces of evidence that were collected from your person. For example, in a drug crime, we're talking about a little sack of marijuana or a couple of crack rocks in a baggie that are found in your pocket when the police arrest you. That would be direct evidence. Then the state would also rely on testimonial evidence, which would be the testimony of witnesses who were called to testify against you at a trial. So in many drug possession cases, that usually comes from police officers who witness hand-to-hand drug transactions on the street, officers who search homes or businesses and find large amounts of drugs pursuant to a search warrant, or perhaps even confidential informants, people who were used either as undercover cops or private citizens who were used as confidential informants to further the investigation of drug crimes. Then there's circumstantial evidence. And by circumstantial evidence, what they will do is they will provide evidence of other things. It may not directly point to you having been in possession of drugs, but they can have people testify that they saw you going to a certain location on certain days. They can testify that they know that at this location people usually have drugs. They can testify that you had an odor of marijuana coming from your car, or that your eyes were red. Things like that, that when all tied up together, tend to prove, based on those circumstances, that you were in fact in possession of drugs at the time the state is accusing you. The point is that with a licensed criminal defense attorney by your side, someone with experience in fighting these crimes, they can attack the sufficiency of that evidence such that the state can't prove its case beyond to the exclusion of every reasonable doubt, and you can be found not guilty.